Welcome to Ask the Lawyer, International Edition, the radio show that brings you the latest trends in immigrating to the United States. Hosted by attorney Brian Figueroa of the law firm Figueroa and Associates. This program is designed to provide valuable insights for those who wish to live, work, study, or invest in the U.S. Whether you're an international student seeking educational opportunities, an entertainer looking to break into the U.S. market, or a business owner wanting to expand your operations and tap into the vast U.S. economy, this show is for you. If you're an investor exploring options in the U.S. or someone with family or friends already living here, you won't want to miss the important information shared on Ask the Lawyer, International Edition. Each week, we dive into critical topics that help you navigate the complexities of U.S. immigration and business law. Special guests include experts in business development, elected officials supportive of immigration, business owners, and nonprofit leaders who provide real-world advice and guidance for those wanting to build a future in the U.S. The law firm of Figueroa and Associates was founded not only to serve our clients, but to contribute to the greater good. We understand the importance of helping individuals and businesses achieve their American dreams, and we are committed to providing the legal expertise and support needed to make that happen. So whether you're an entrepreneur looking to open a branch of your business in the U.S., an investor ready to explore opportunities, or someone hoping to migrate and build a new life in America, you should tune in and learn from this informative program. Ask the Lawyer. International Edition is your resource for understanding U.S. immigration trends, business opportunities, and legal strategies. Call now. For personalized legal advice, contact the experienced attorneys at Figueroa and Associates today. Our team is here to help you navigate the path to success in the U.S. Thank you for listening to Ask the Lawyer, International Edition with attorney Brian Figueroa. Visit us online at askthelawyer.us or call today to schedule your consultation.
Good day, good day, good day. My name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. Thank you to our listenership in Jamaica, Grenada, Trinidad and Tobago, because, hey, one big issue that has, surfaced is what we call derivative citizenship. When people are placed in deportation, what starts the proceedings is what we call a NTA, a notice to appear. On the notice to appear, there are different allegations, 5-7 of them. One of them is that you are not a U.S. citizen. And the standard practice of our law firm is we obviously want to know whether or not that person is a U.S. citizen. They may have a green card, but they also may be a citizen and they do not know. Yes. And unfortunately, people have been deported from the United States of America that are U.S. citizens. Yes. Why? Because people may represent themselves, because you don't have a right to an attorney. People may have an attorney that lacks experience. That unfortunately may be common. And what you need is a competent attorney that has done these type of hearings representing people on deportation matters. What is the relief for deportation for green card holders? It's either cancellation of removal if you're here for 7 years with a green card, cancellation of removal if you're here for 10 years without a green card, political asylum, and other defenses. However, from the time your first hearing at immigration court, you never plead and say, I am not a citizen. You need to consult with an attorney. Whether represented or not, are you a U.S. citizen? Now, in December 2001, derivative citizenship was simplified by the Child Act. What does that mean? If you are a green card holder and your parents became a U.S. citizen before your 18th birthday, you are automatically a citizen. Prior to December 21st, 2000, you had to look at different issues. One, were your parents married? Two, were one of your parents a step-parents? Three, whether or not under the bastard law, yes, a bastard is someone born out of wedlock, that's what they called it, and still do. What was the bastard law in Jamaica? What was the bastard law in TNT, Ghana, Nigeria? So it was a complicated way of determining whether or not you was a derivative citizen, and if you was a bastard, that was a negative for you, unfortunately. It is a way of, obviously, people, the U.S. government encouraging people, to be married before they have a child. So we have had calls from different islands where we have had people that have been ordered deported that are U.S. citizens. And obviously, those people would like to re-enter the United States of America. If you believe that you are a U.S. citizen and wrongly deported, we could fix that situation for you. Give us a call. Again, the number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. For those of you who might be in the U.S. and you think you may be a derivative citizen, you should also give us a call. Because with your citizenship, you will have many different benefits that obviously green card holders do not have. Again, my name is Brian Figueroa of the law firm Figueroa & Associates. This is Ask the Lawyer. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. And yes, they didn't like bastards. I was a bastard, and look how I, prospered in life. Peace to God.
Are you planning a trip to the United States but unsure how to navigate the visa process? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys will guide you step by step through the visitor's visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand in the way of your dream vacation. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless clients like you successfully secure their U.S. visas. Let us take the stress out of the process so you can focus on planning your perfect trip.
Are you a religious worker looking to come to the U.S. to fulfill your mission? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to help you navigate the complex R1 visa process. Whether you're a minister, missionary, or religious professional, our experienced immigration attorneys can assist with every step, from securing a U.S.-based sponsor to filing petitions with USCIS and preparing for your consular interview. Don't let the paperwork stand in the way of your spiritual calling. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845 to discuss your case with our legal team. Figueroa & Associates, your trusted partner in U.S. immigration law for religious workers. Call Figueroa & Associates today.
Are you an artist, band, or musician looking to perform in the United States but need help navigating the complex visa process? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to assist. Our experienced immigration attorneys specialize in entertainer visas, including P1, P2, and P3 visas. We'll guide you through every step, from securing a U.S. sponsor to filing the necessary petitions and preparing for your consular interview. With our legal expertise, we'll ensure that your visa application process is smooth and stress-free so you can focus on what you do best, performing. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Figaro and Associates, your trusted partner in U.S. immigration law for entertainers.
If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay, but the law firm of Figaro and Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Get the right legal help when it matters most.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
One of the most common pathways to obtaining permanent residency, commonly known as a green card in the United States, is through family-based immigration. U.S. citizens and lawful permanent residents, green card holders, can petition for certain family members living overseas to join them in the U.S. and apply for permanent residency. This process is known as family-based immigration, and it requires several steps that must be carefully followed to ensure success. In this article, we will break down the process for someone living overseas to have a U.S. citizen or green card holder family member petition for their green card. We will also explore how this process might impact any existing U.S. visitor visas, what to expect in terms of timelines, and potential challenges that may arise. Overview of family-based immigration. Family-based immigration allows U.S. citizens and lawful permanent residents, LPRs, to sponsor certain relatives to immigrate to the United States. The process involves filing a petition, going through consular processing for family members overseas, and ultimately obtaining a green card. Categories of family members eligible for sponsorship. The eligibility to sponsor a family member for a green card depends on the petitioner's status, whether they are a U.S. citizen or green card holder, and the relationship to the relative. For U.S. citizens, they can sponsor immediate relatives, which include spouses, parents, if the petitioner is over 21, and unmarried children under 21 years old. These categories are not subject to visa quotas, which means there is no waiting period once the petition is approved. Other family members, including unmarried sons and daughters over 21. Married children of any age, siblings, if the petitioner is over 21. For green card holders, lawful permanent residents, they can sponsor spouses. Unmarried children regardless of age. Green card holders cannot sponsor married children or siblings. Preference categories and visa availability. Family-based immigration for relatives outside the immediate relatives category is subject to visa availability under the preference category system. Immediate relatives of U.S. citizens are not subject to numerical limits, but other family categories like siblings of U.S. citizens or spouses of green card holders are subject to annual limits, which can create long waiting times depending on the relationship and the petitioner's country of origin. First preference, F1. Unmarried adult children over 21 of U.S. citizens. Second preference, F2A and F2B, spouses and children of green card holders, F2A, and unmarried adult children over 21 of green card holders, F2B. Third preference, F3, married children of U.S. citizens. Fourth preference, F4, siblings of U.S. citizens. Once the petition is approved and the visa becomes available for the relative, the process moves forward to consular processing or adjustment of status if they are already in the U.S. Step-by-step process for family-based green card petition for overseas relatives. Step 1. Filing Form I-130, Petition for Alien Relative. The process begins when the U.S. citizen or green card holder files a Form I-130, Petition for Alien Relative with U.S. Citizenship and Immigration Services, USCIS. This form establishes the family relationship between the petitioner, U.S. citizen or green card holder, and the beneficiary, the relative living overseas. Supporting documents. The petitioner will need to submit supporting documents proving their relationship with the beneficiary. This may include birth certificates, marriage certificates, or proof of adoption, depending on the relationship. Filing fee. As of 2024, the filing fee for Form I-130 is $535, but it's advisable to check the USCIS website for current fees. Once USCIS receives the I-130 petition, they will review it and either approve or deny the application. Processing times can vary, but it generally takes several months for USCIS to adjudicate the I-130 petition. Step 2. Wait for approval and visa availability. If the I-130 petition is approved, the next step depends on the family member's category. Immediate relatives, spouses, parents, unmarried children under 21 of U.S. citizens. These applicants can proceed directly to the next steps, as visas are immediately available. Preference categories. A. Adult children, siblings. For relatives who fall under preference categories, the approved petition enters the visa queue. Because of annual visa caps, applicants may have to wait for their priority date, the date the I-130 petition was filed, to become current based on the Visa Bulletin, which is updated monthly by the U.S. Department of State. Step 3. Consular processing for overseas relatives. Once the visa is available, overseas applicants go through consular processing. This involves the following steps. National Visa Center, NVC processing. After USCIS approves the petition and the visa becomes available, the case is transferred to the National Visa Center, NVC, which collects fees and documentation to prepare for the visa interview. Complete Form DS-260. The beneficiary, overseas family member, must complete Form DS-260, which is the online immigrant visa application. This form asks for detailed personal information, including background, employment history, and travel history. Submit supporting documents. The NVC will also require submission of supporting documents such as police clearance certificates, medical exams, financial support affidavits, and civil documents like birth certificates and marriage certificates. Pay visa fees. Fees for the immigrant visa application, affidavit of support processing, and medical exam must be paid during this stage. As of 2024, the total cost of consular processing can range from $300 to $400, depending on various factors. Step 4. Attend the visa interview at the U.S. consulate. Once all documents are submitted and processed, the applicant will be scheduled for a visa interview at the U.S. embassy or consulate in their home country. During this interview, a consular officer will ask questions to verify the relationship, ensure that the applicant is eligible for immigration, and assess the legitimacy of the application. Bring required documents. The applicant must bring all required documents to the interview, including their passport, photos, medical exam results, and financial support documentation. Outcome. If approved, the beneficiary will receive an immigrant visa and their passport, which allows them to travel to the U.S. as a lawful permanent resident. Step 5. Enter the U.S. and receive the green card. Upon entering the U.S. with the immigrant visa, the beneficiary will be processed by Customs and Border Protection, CBP, at the port of entry. They will receive a stamp in their passport, which serves as proof of lawful permanent resident status, green card, until the official green card arrives by mail. Impact of family-based green card petition on a visitor visa. Many individuals who have a visitor visa B1/B2 to the U.S. may wonder how filing for a green card through a family member might affect their current visa status. Here are a few key points to consider. Dual intent. A visitor visa is intended for short-term stays for purposes like tourism, medical treatment, or business. The visa does not allow the holder to remain in the U.S. permanently. Filing a family-based green card petition could raise concerns about immigrant intent, as applying for a green card indicates a desire to stay in the U.S. permanently. This can potentially lead to challenges if the individual tries to enter the U.S. on a visitor visa while their green card application is pending. Visa denial or revocation. If a visitor visa holder applies for a green card, their visitor visa may be scrutinized more closely. In some cases, visa officers at U.S. embassies or consulates could deny or revoke the visitor visa, particularly if they believe the individual intends to overstay their visa while waiting for their green card. Honesty at the border. If someone holding a visitor visa tries to enter the U.S. while they have a green card petition pending, they should be prepared to explain their intentions honestly to U.S. border officials. Misrepresenting their intentions can lead to a visa being canceled or even a ban from entering the U.S. In summary, filing for a green card through a family-based petition can affect a person's visitor visa. it's essential to consult an immigration attorney before traveling on a visitor visa during the green card application process. The family-based green card process for relatives living overseas involves multiple steps, from filing the initial I-130 petition to attending a consular interview and entering the U.S. as a lawful permanent resident. For U.S. citizens and green card holders, this process is a way to reunite with family members in the United States, but it requires careful preparation and attention to legal details. Furthermore, it's important to understand the potential impact of filing a green card petition on an existing visitor visa. Navigating these complexities can be challenging, so working with an experienced immigration attorney can be essential in ensuring a smooth process. The law firm of Figueroa and Associates, which has over 25 years practicing immigration law, can help you navigate the process and avoid common pitfalls. To schedule an appointment, visit www.askthelawyer.us or call 855-768-8845. The lawyer you hire does make a difference.
Do you have a family member overseas that you want to bring to the United States? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you're a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today. Visit askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. Figueroa and Associates, your trusted partner in family immigration law.
Are you looking to study in the United States but confused about how to apply for a student visa? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in guiding students through the visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand between you and your academic dreams in the U.S. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless students secure their student visas and begin their educational journey in the United States. Let us help you make your study abroad dream a reality. Figueroa and Associates, your trusted partner in student visa success.
If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay, but the law firm of Figueroa and Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Get the right legal help when it matters most.
Attention green card holders. Have you been outside the United States for more than a year? Are you holding an old green card without an expiration date? These situations can jeopardize your permanent resident status. At Figueroa and Associates, we specialize in immigration law and can guide you through these complex issues. We are located at 26 Court Street, Suite 701, downtown Brooklyn. We are here to help you navigate the legal maze. Don't wait until it's too late. Call us today at 855-768-8845 to schedule a consultation. Protect your status and secure your future with Figueroa and Associates. Figueroa and Associates, your trusted partner in immigration law. Call 855-768-8845 now or visit askthelawyer.us to schedule an appointment today.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa and Associates. For a consultation on any immigration or legal matter, please call 855-768-8845 That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figueroa and Associates, and your presenter with a special immigration report. The consequences of getting married after an approval as a child, but before entering the U.S. for green card purposes. The U.S. immigration system has strict eligibility requirements for family-based green cards, particularly for children of U.S. citizens or permanent residents. If a person is approved for a green card under the classification of a child, unmarried, and under 21, getting married before entering the U.S. can have serious legal consequences. This article explores the impact of marriage on the green card process after consular approval but before entry, the potential loss of status, alternative options, and legal remedies available. Understanding child-based immigration categories. In U.S. immigration law, the term child has a specific meaning. Immediate relative, IR2, category, for unmarried children under 21 of U.S. citizens. F2A category, for unmarried children under 21 of lawful permanent residents green card holders. F1 category, for unmarried sons and daughters 21 or older of U.S. citizens. A critical condition for these classifications is marital status. If a person classified as a child marries before entering the U.S., they may lose their eligibility for the visa. Consequences of getting married after consular approval but before entering the U.S. 1. Automatic revocation of visa approval. Marriage before entry into the U.S. can lead to the automatic revocation of the immigrant visa under the IR2 or F2A categories. This happens because the U.S. consulate approves the visa based on the applicant being unmarried at the time of processing. Marriage changes the applicant's status, making them ineligible for their approved visa. If a person in the IR2 or F2A category gets married, their visa automatically becomes invalid, and they cannot use it to enter the U.S. too. Denial of entry at the U.S. port of entry. Even if the applicant does not disclose their marriage at the time of visa issuance, Customs and Border Protection, CBP, officers at the port of entry have the authority to review visa eligibility upon arrival. Ask questions about the applicant's marital status. Deny entry if they discover that the applicant has married after consular approval but before entry. Attempting to enter the U.S. under a visa classification that no longer applies due to marriage may be considered fraudulent entry, leading to severe immigration consequences. 3. Possible immigration fraud accusations. If the person fails to disclose their marriage and tries to enter the U.S., they may be accused of misrepresentation or immigration fraud. This can result in a permanent bar from entering the U.S. under Section 212(6)(c) of the Immigration and Nationality Act, INA. Denial of future immigration benefits, including family-based green cards. Possible deportation if the fraud is discovered later. Honesty and full disclosure with U.S. immigration authorities are crucial to avoiding these severe consequences. Alternative options for married applicants. 1. Reapplying under a different family-based category. If the applicant gets married before entering the U.S., they are no longer eligible under the IR2 or F2 of visa categories. However, they may still be eligible under a different category. If the petitioner is a U.S. citizen, the applicant can be reclassified under the F3, married sons and daughters of U.S. citizens category. If the petitioner is a green card holder, the applicant is no longer eligible because there is no category for married children of lawful permanent residents. The petitioner must wait until they become a U.S. citizen to file a new petition under the F3 category. 2. Seeking a K3 or K1 visa through a U.S. citizen spouse. If the applicant marries a U.S. citizen instead of keeping their original petition, the U.S. citizen spouse can file an I-130 petition for alien relative for the applicant under the immediate relative spouse, IR1 category. Alternatively, if the applicant is overseas, they may apply for a K3 non-immigrant visa, allowing them to enter the U.S. while waiting for their green card processing. If the marriage occurred before visa approval but not disclosed, it may be necessary to withdraw the old petition and file a new one based on the new relationship. 3. Exploring employment-based or diversity visa options. If family-based immigration is no longer an option due to marriage, the applicant may consider employment-based immigration, such as H-1B or EB-3 sponsorship, the diversity visa DV lottery, if eligible based on their country of birth. These options may provide alternative pathways to enter the U.S. legally without relying on family sponsorship. Legal remedies if marriage occurs after visa issuance. 1. Requesting reclassification before entering the U.S. If the applicant has already received a visa but gets married before traveling, they should immediately notify the U.S. Embassy or consulate where the visa was issued. Request reclassification under the appropriate category, F3 for married children of U.S. citizens. Avoid using the invalid visa, as attempting to enter the U.S. under false pretenses can result in serious consequences. 2. Filing a waiver for misrepresentation, if necessary. If the applicant unintentionally fails to disclose their marriage and enters the U.S., they may be found inadmissible. In such cases, they may need to file a waiver of inadmissibility, Form I-601, based on extreme hardship to a U.S. citizen or permanent resident family member. However, approval of such waivers is not guaranteed and requires strong evidence. 3. Seeking legal counsel for possible adjustments. An immigration attorney can help determine the best course of action, including filing a new family-based petition under the correct category, exploring humanitarian relief or legal forgiveness options if an error was made, advising on the best way to correct the situation without further jeopardizing immigration status. Conclusion: getting married after receiving a visa approval as a child but before entering the U.S. can have significant consequences. The visa becomes invalid, and the applicant may be denied entry or even accused of immigration fraud if they fail to disclose their new marital status. However, alternative immigration pathways exist, including reapplying under a different family-based category or seeking an employment-based visa. Transparency with U.S. immigration authorities is essential to avoid legal complications. If a mistake has been made, consulting an immigration attorney can help navigate the best legal remedies available.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa & Associates. For a consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Estate planning is a necessity, not a luxury. Let the law firm of Figueroa & Associates help you protect your legacy, assets, and loved ones. Get estate planning consultation on wills, living trusts and probate, power of attorney, health proxy, deed transfers, providing for special needs, disabled children and grandchildren, minimizing federal and state taxes. Call us right now at 855-768-8845. That's 855-768-8845. Or schedule an appointment at www.askthelawyer.us. That's www.askthelawyer.us.
Are you an artist, band, or musician looking to perform in the United States but need help navigating the complex visa process? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to assist. Our experienced immigration attorneys specialize in entertainer visas, including P1, P2, and P3 visas. We'll guide you through every step, from securing a U.S. sponsor to filing the necessary petitions and preparing for your consular interview. With our legal expertise, we'll ensure that your visa application process is smooth and stress-free so you can focus on what you do best, performing. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Figueroa & Associates, your trusted partner in U.S. immigration law for entertainers. Are you planning a trip to the United States but unsure how to navigate the visa process? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys will guide you step by step through the visitor's visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand in the way of your dream vacation. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless clients like you successfully secure their U.S. visas. Let us take the stress out of the process so you can focus on planning your perfect trip. Are you visiting the U.S. and need to extend your stay due to an extended vacation or an emergency? The process can be complicated, but the law firm of Figaro and Associates located in Brooklyn, New York is here to help. Our experienced immigration attorneys can assist you in filing for an extension of your stay, ensuring all paperwork is handled properly and on time. Schedule a consultation today at www.askthelawyer.us or call us at 855-768-8845. Let Figaro and Associates guide you through the process with confidence.
I have been deported. Can I return to the United States? Returning to the U.S. after deportation is a challenging process, but it's not impossible. Here are some key points. A. Deportation grounds. People are deported for various reasons, including entering the United States without permission, B. Violating immigration status terms, C. Criminal offenses leading to deportability, and D. Security-related concerns. Things to consider are A. The inadmissibility period. After deportation, individuals are inadmissible for a specified period. The length of inadmissibility depends on the reasons for removal, the number of removals, and whether they are left voluntarily or after removal hearings. Some grounds of removal allow for waivers, except security-related grounds. Waivers may reduce the waiting period for re-entry, and severity of removal grounds affect waiver approval likelihood. How to get back. Form I-212 application. Individuals seeking re-entry file Form I-212 to request permission. USCIS then reviews the application and grants permission if eligible. Please note that U.S. citizens cannot be legally deported. They can return to the U.S. at any time. How to prove that you're a U.S. citizen? Determining your U.S. citizenship depends on various factors. Here are some scenarios to consider. Were you born in the U.S.? If you were born in the U.S., your birth certificate issued in the United States is proof of your citizenship. Do you have grandparents or parents born in the United States? You may be a U.S. citizen if one of your parents or grandparents was born in the United States or its territories. Additionally, if one or both of your parents became a naturalized U.S. citizen before your 18th birthday, you may also be a U.S. citizen. Naturalization. If you're a lawful permanent resident, a green card holder, you can apply for naturalization after meeting specific requirements established by Congress in the Immigration and Nationality Act. Always remember to consult a legal professional. For personalized guidance, consult with the immigration attorney or visit the U.S. Citizenship and Immigration Services website for detailed information. If you have been dipped and dissed and want to come back to the United States, or if you want to prevent being dipped, call us at 855-768-8845. That's 855-768-8845. Or schedule an appointment with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer. You have questions? We've got the answers.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
How a religious worker living overseas can successfully apply for an R visa to perform religious work in the U.S. For religious workers living overseas, the R1 visa provides an opportunity to come to the United States and serve their religious community. Whether you are a minister, a missionary, or a religious professional, this visa allows you to perform religious work on behalf of a legitimate U.S.-based religious organization. The R1 visa is an essential tool for churches, temples, mosques, and other religious institutions in the U.S. that rely on foreign workers to fulfill spiritual needs and carry out religious missions. In this comprehensive analysis, we will explore the process of applying for an R1 visa, covering the eligibility requirements, step-by-step application process, consular involvement, and practical advice for overseas religious workers seeking to come to the United States to perform religious work. We'll also address potential challenges and provide helpful tips for navigating U.S. immigration law in this context. Understanding the R visa category. The R1 visa is a non-immigrant visa for individuals who wish to come to the U.S. temporarily to perform religious work. This visa is available to individuals who are part of a bona fide nonprofit religious organization in the United States, and it applies to various religious roles such as ministers, missionaries, and those working in religious vocations or occupations. Key features of the R1 visa: temporary religious work. The R1 visa is specifically for individuals entering the U.S. to work in a religious capacity for a recognized religious organization. This includes ministers, religious instructors, or those involved in other religious vocations. Duration. The R1 visa is typically issued for an initial period of up to 30 months, 2.5 years, and can be extended for an additional 30 months, with a total maximum stay of 5 years. Family. R1 visa holders can bring their spouse and unmarried children under 21 years of age to the U.S. under R2 visas. However, R2 visa holders cannot work in the U.S. but can attend school. Path to permanent residency. While the R1 visa is a non-immigrant visa, it does allow for dual intent, meaning religious workers can apply for permanent residency, green card, later if they meet the eligibility requirements. To qualify for an R1 visa, the applicant and their religious organization must meet several criteria, and the application process involves both U.S. Citizenship and Immigration Services, USCIS, and the U.S. Consulate in the applicant's home country. 2. Eligibility requirements for an R1 visa. Before applying for an R1 visa, it's essential to ensure that both the religious worker and the U.S.-based religious organization meet the required criteria. These include: 1. Religious worker qualifications. To qualify for an R1 visa, the applicant must demonstrate that they are part of a recognized religious organization and that they will perform religious work in the U.S. specifically. Membership in the religious organization. The applicant must have been a member of the religious denomination for at least 2 years prior to applying for the R1 visa. Full-time employment. The religious work must be full-time, defined as at least 35 hours per week. This work must involve a traditional religious function, such as teaching religion, conducting worship services, or performing missionary work. Types of religious work. The applicant must be a minister, religious professional, or someone working in a religious vocation, such as a monk or nun, or occupation, such as a translator of religious texts. 2. U.S.-based religious organization requirements. The religious organization that will employ the worker in the U.S. must meet the following criteria. Nonprofit status. The organization must be a nonprofit religious organization recognized by the U.S. Internal Revenue Service, IRS, as tax-exempt under Section 503 of the IRS Code. Ability to pay. The organization must demonstrate its ability to provide financial compensation or support to the religious worker during their stay in the U.S. Valid religious purpose. The organization must engage in traditional religious functions, such as conducting worship services, religious education, or missionary work. Once both the applicant and the religious organization meet these eligibility requirements, the application process can begin. 3. Step-by-step process for applying for an R visa. Step 1. U.S.-based religious organization files Form I-129. The application process for an R1 visa starts with the U.S.-based religious organization filing Form I-129, Petition for an Immigrant Worker. This petition is filed with U.S. Citizenship and Immigration Services, USCIS, and is necessary to prove that the religious worker meets all the requirements for the R1 visa. Supporting documentation. Along with Form I-129, the organization must submit evidence of its nonprofit status, proof of the religious worker's qualifications, religious training, membership, and a detailed description of the duties the worker will perform in the U.S. Filing fee. As of 2024, the filing fee for Form I-129 is $460. It's crucial to check the USCIS website for the most up-to-date fees before submitting the petition. Processing time. USCIS processing times for Form I-129 can vary, but they generally take several months. However, premium processing is available for an additional fee, which guarantees a decision within 15 calendar days. Step 2. Wait for USCIS approval. Once USCIS receives Form I-129, they will review the petition and supporting documentation. If everything is in order, they will approve the petition and issue a Notice of Approval, Form I-797. This approval is necessary before the religious worker can apply for an R1 visa at the U.S. consulate in their home country. Premium processing. If time is a critical factor, the religious organization can opt for premium processing to expedite the approval of the I-129 petition. Step 3. Apply for the R visa at the U.S. consulate. After the I-129 petition is approved by USCIS, the religious worker must apply for the R1 visa at the U.S. consulate or embassy in their home country. This stage involves completing an online application and attending an interview at the consulate. Complete Form DS-160. The religious worker must fill out Form DS-160, the online non-immigrant visa application. This form collects personal information about the applicant, including details about their background, employment history, and the purpose of their visit to the U.S. Pay visa fees. The visa application fee for an R1 visa is currently $190 as of 2024. Applicants should check the latest visa fee rates on the U.S. Department of State website. Schedule a visa interview. After submitting the DS-160 form, the applicant must schedule an interview at the nearest U.S. consulate or embassy. The interview wait times vary depending on the location, so it's advisable to schedule as early as possible. Step 4. Attend the visa interview. The visa interview is a critical step in the process. During the interview, the consular officer will review the applicant's petition, supporting documents, and ask questions to confirm the purpose of the trip and the applicant's qualifications. Documents to bring. The applicant should bring the following to the visa interview: A valid passport with at least 6 months of validity remaining. A visa fee payment receipt. DS-160 confirmation page. A Form I-797. Notice of approval from USCIS. Supporting documentation from the religious organization, such as evidence of the applicant's qualifications and the purpose of the trip. Interview questions. The consular officer will likely ask about the nature of the religious work, the applicant's membership in the religious organization, and their intended stay in the U.S. The officer may also ask about ties to the applicant's home country to ensure that they will return after completing their religious work. Step 5. Visa approval and entry into the U.S. If the visa is approved, the applicant will receive their passport with an R1 visa stamp. This visa allows them to travel to the U.S. and begin their religious work. Port of entry. Upon arriving in the U.S., the religious worker will be inspected by U.S. Customs and Border Protection, CBP, officers at the port of entry. CBP officers will review the visa and issue an I-94 arrival/departure record, which will indicate the length of time the worker is authorized to stay in the U.S. Commencement of religious work. Once admitted to the U.S., the religious worker can begin their duties as outlined in the approved I-129 petition. 4. Key considerations for our visa applicants. 1. Extension of stay and maximum duration. The initial R1 visa is typically issued for a period of up to 30 months. Religious workers who wish to continue their work in the U.S. can apply for an extension of their stay, with a maximum total stay of 5 years. To apply for an extension, the religious organization must file another Form I-129 on the worker's behalf. 2. Path to permanent residency. While the R1 visa is a temporary, non-immigrant visa, it allows for dual intent, meaning the religious worker may eventually apply for a green card, permanent residency, if they meet the eligibility criteria. This can be done through the EB-4 Special Immigrant category, which is specifically for religious workers who have been employed in the U.S. for a certain period of time. 3. Family members. spouses and unmarried children under 21 of R1 visa holders can apply for R2 visas to accompany or join the religious worker in the U.S. While R2 visa holders are not allowed to work in the U.S., they are permitted to attend school or pursue other educational opportunities. 5. The R1 visa offers a vital pathway for religious workers from overseas to come to the United States and contribute to the religious and spiritual life of communities across the country. From ministers and missionaries to religious professionals working in a vocation or occupation, the R1 visa allows religious workers to fulfill their callings while performing critical roles within their organizations. The process involves several steps, from securing sponsorship from a U.S.-based religious organization to filing petitions with USCIS and attending a consular interview. While the process can seem complex, careful preparation and following the specific requirements will help ensure a successful visa application. For religious workers seeking long-term residency, the R1 visa also opens the door to potential green card eligibility under the EB-4 category. Whether for a short-term mission or a longer-term commitment, the R1 visa is a valuable option for those who wish to serve in the U.S. religious. The law firm of Figueroa and Associates, which has over 25 years practicing immigration law, can help you navigate the process and avoid common pitfalls. To schedule an appointment, visit www.askthelawyer.us or call 855-768-8845. The lawyer you hire does make a difference.
Do you have a family member overseas that you want to bring to the United States? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you're a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today. Visit askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. Figueroa and Associates, your trusted partner in family immigration law.
Are you a religious worker looking to come to the U.S. to fulfill your mission? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help you navigate the complex R1 visa process. Whether you're a minister, missionary, or religious professional, our experienced immigration attorneys can assist with every step, from securing a U.S.-based sponsor to filing petitions with USCIS and preparing for your consular interview. Don't let the paperwork stand in the way of your spiritual calling. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845 to discuss your case with our legal team. Figueroa and Associates, your trusted partner in U.S. immigration law for religious workers. Call Figueroa and Associates today.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
This show is a production of IQ Inc. Marketing. If you would like to advertise your product or service on this show to the U.S. and Caribbean markets and through our multicultural publications in New York, please call 866-435-3286 or send an email to info@myiqinc.com.
Thank you for listening to Ask the Lawyer International Edition with attorney Brian Figueroa of the law firm Figueroa and Associates in New York. We hope you enjoyed the show. which featured immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768-8845. That's 855-768-8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer, International Edition. You have questions? We've got the answers.